morning, everyone. Welcome to another Swift Chat. We have a very interesting guest today. I have a lawyer with me, one of many lawyers in the city. I have a lawyer, Leslie Robinson. He's joining us, and we're going to have a long discussion or detailed discussion about some of the issues that not only homeowners and buyers and sellers deal with, but a little bit of education for first-time home buyers, so they know why a lawyer is involved and what everything entails with working with a lawyer. So Leslie, welcome.
Thank you for having me.
You're welcome. I'm glad to take your Saturday morning, wake you up and make you come.
It's all right. Slogging through the snow, it's okay.
Yeah, it's not so bad. It's not so bad. So tell us a little bit about your background and what you're doing now.
So I am a lawyer based in Toronto. My practice focuses on two specific areas. The first is residential real estate transactions.
Okay.
That kind of encompasses everything from purchase transactions, sale transactions, and private lending transactions. And I'm also an estates lawyer.
Okay.
And so we assist our clients with both preparing their wills and powers of attorney, as well as all of the estate administration that may happen after the fact. And one thing that I think is an interesting thing that comes up with a lot of files is that there's a real overlap in real estate with a lot of estate issues. And so those are the two areas that I work within. I'm a graduate of the University of Ottawa's Faculty of Law, and before that I went to the University of Toronto.
Okay, cool. So you have some education too.
I hope to use it. Yeah.
Oh, I see.
Yeah.
With real estate transactions, do you deal with any litigation, or is that someone else takes care of that? So if someone has a dispute over property lines or issues with things that may not have been disclosed, like shared easement or rights of way or those types of things, do you deal with that, or is that's another department of real estate law?
So the answer is that it depends. In an agreement of purchase and sale, in the prescribed clauses, there are provisions about things that a buyer will assume with respect to certain types of easement issues. More complex issues that might become fatal to a deal if we are not able to rectify and remedy the issue before closing, or it can't be rectified after closing. I do have a litigation referral. And so where we have files where at any point we think that it may have to go somewhere else, we make sure that we have those conversations with the clients, because I'm not a litigation lawyer.
Okay. Yeah, and I've had with the Royal Page teams that I work with, we have 4 or 5 litigators. It's like, it seems like it's become more common to have more litigation with some real estate deals than sort of in the past. That's been my experience. So
I've noticed in the past couple of years, more files have been referred out to litigation counsel, specifically in the pre-construction area, where people were simply not able to find the funding because of market dips, and they couldn't assign things. So we were finding more files being referred out for those. I did have a file in the past week or so where I have a client who just was not able to fulfill all of the requirements as a buyer for his closing. No deposit was paid. We chased him, and so we made sure that we were referring that out afterwards, because these things do happen, unfortunately, sometimes. But we have to know at what point we're not going to be able to service a client.
Right, and be able to say, hey, this is not something we can do.
Yeah.
Yeah. Hopefully that's not too often. I've been pretty lucky. I've not had deals like that. Occasionally, I think our biggest challenge are with people who are self-employed. Because, it's like, what income is being stated? Have they done this before? What type of business are they running? Are they trying to run it in their home? Is it legal to do that? Can you do it? And what's the city say? What's the township say? Run into this a number of times.
Yeah, and some of those issues are on the qualifying side for a mortgage, and sometimes they may also be issues that you need to deal with an accountant after the fact, right, for your annual filings. So there's a whole bunch of things that people need to think about.
Yeah, they think, it's just easy. The real estate lawyer just signs things and we're done. And it's like, no. We'll talk about the process. We'll talk about the process. No, I think when I talk about, because I do a lot of work with first-time home buyers. So we start with their financial plan, they're pre-qualify with their mortgage, working with the realtor, and then it's like, now we're bringing the lawyer in. And the last person we're bringing in is the insurance person. But it's like the lawyer becomes the one that's like, once we've found a place, they're the ones that kind of take over and work it towards the end.
Yeah, I kind of think of my job specifically for the buyers is really we're quarterbacking a transaction for you. My team and I, we're here to assist you and guide you through the process. And where our clients are first-time home buyers, or even if someone who hasn't bought in a long time, we want to make sure we give a little extra attention, and so that we can guide you through the process, because there's a lot of things that people don't know, they hadn't thought about, and they just have general questions, and we want to make sure that they're informed and they know what to expect, because you don't know what you don't know.
And things change.
They can, and with respect to first-time home buyers, a lot of times the questions are about the applicability of the first-time home buyers rebate. And so we try to guide our clients through when they may not be applicable, depending on their spousal status, or how that might affect it. Or also making sure people understand, if you're buying in Toronto, the implications of the double land transfer tax regime that we have. But also all of the things that kind of go into home ownership that they may not have even thought about. And in the past year or so, we've been getting a lot more clients who are finding really creative ways to get into the market by investing with friends or colleagues into housing that allows for multiple families, for example. And so that has changed the types of advice that we've been giving. And to some extent, the services that we offer, because we've been doing a lot more co-ownership agreements, because there's definitely complexities and nuances to transactions involving multiple parties.
Right.
And that changes the types of things that people have to think about in terms of how they're going to manage a property and their capital and ongoing expenses.
Right. Yeah, and that's very new in the market.
Yeah.
And I haven't had anyone come to me. I've talked to folks about that as first-time home buyers. It's like, do you have friends? Is this something you've thought about? And it's like, okay, do I trust them enough? Do they trust me enough to do this type of process? So it's a whole other ball of wax.
Yeah.
And for me, it's like I have enough information to get people started, but I'm like, I can get you started, but here's the person that's going to advise you about all of the very specifics.
Yeah.
And so it's knowing where my ballpark ends and your ballpark begins.
And in our as well, when we need to bring on additional lawyers, if independent legal advice is required as well, because that does happen. In the standard transaction, it doesn't,
Right.
but in some of these more interesting transactions, they can.
Yeah, complex ones.
Yeah.
So let's talk a little bit about first-time home buyers.
Okay.
Okay. When should a client, I'm presuming that's the term you use, when should a client first contact or reach out to a lawyer?
It's an interesting question, because I've always explained to many people that real estate transactions are sort of a backwards process. Typically, when you need a contract prepared, whether it's an employment issue or a civil issue, you often will go to a lawyer who will help you draft the contract. Real estate's a little bit different. Usually you work with your agent who will prepare the agreement of purchase and sale. You sign the documents, and then during your conditional period, it may or may not go to a lawyer. It should. And then that's sort of the typical course. So the agreements don't come to us often beforehand, but it's often good for people to reach out to a lawyer before they even start looking around with an agent, so we can kind of give them some high-level things that they may want to think about while they're going around and looking at properties that they may want to put an offer on, and before they make their deposit. So I don't think there's ever a time when it's too early, but often the case is that we get brought in after something is signed.
So with homes and condos, there's a bit of difference, and some buyers and sellers know that, some don't. So I'm operating from the avenue of someone doesn't really know anything.
Yeah.
So with a condo purchase, we have a few other things that come into play.
Yeah.
Such as the status certificate.
Yeah.
And I explain to people the status certificate is like the health of the building.
Yeah.
How do you deal with status certificates? Do you want the buyer to pass it past you? Do you want them to trust their own instinct, to go to their accountant? How would you, what's the ideal for a client who's now got a status certificate in hand?
Yeah, so you explained what a status certificate is pretty well, which is basically, it tells us a snapshot of the global health of the condo corporation. Because a condo is a creature of statute, as I like to say. It's the condo corporation brings it together, and so what the status certificate does is it tells us whether if the owner is the owner with property management, the status of their common expenses, if there's any litigation against the corporation, whether there's been any special assessments, and there may be an increase in condo fees, or what the overall budget and those types of things are. And then we also want to review the condo bylaws and other ancillary documents. So especially for a first-time home buyer who's not a savvy condo purchaser, it's a lot of information we're throwing at people. And so I have a structured process. Is we review the status certificate right away, because usually it's conditional for a couple days. And I provide a detailed but fairly easy to understand report of all the things that a client needs to understand.
Okay.
And I flag those in an email, and I will get on the phone with a client to let them know what they're taking a look at and to see if they have any questions. And there might be some issues that we provide for information, but it isn't necessarily fatal. But there's things that people need to understand about when condo fees might change, things that the condo corporation or the building itself think where work needs to be done in the future, things that people might want to know about. And usually there aren't major issues that'll be fatal to a purchase, but there have been a few where there was litigation, or the condo was over leveraged and people decided to back out. So yeah.
And I've seen that happen a lot. And the things, because I'm pretty good at looking at accounts. So I look at the past year, the current year, what's going on, what their expenses are, where there's things that seem out of balance.
Yeah.
And I actually call the corporation or call the selling agents, like, what do you know about, a $30,000 expense this year that didn't happen last year? And just to sort of begin to kind of understand, because I know that as a lawyer, you're going to ask that same question.
Yeah, and the one thing I would also say too is that, we are not actuaries or accountants, but we have to look for red flags.
Right.
And it's those red flags that we need to highlight for clients so that they feel informed, so that they can feel good about the purchase that they're making to move forward for themselves and their families.
And the other things I like to look for is, especially if someone has a pet or is thinking of having a pet, is a restriction. Size restriction, number restriction, because it's like, that's a make or break as well.
Yeah, it could be. I'll give you an example. I have a Doberman. I always wanted one, but I could never have him in any of the condos I lived in previously, because most buildings will have rules and regulations which a buyer will need to know about, which restrict the size of the animals or the types of animals you can have. And all owners have to abide by them. And so generally in a status certificate review, what we tend to do is let the client know that the building will have these types of provisions, and so you need to take a look at them to see if they will impact you at all, because one buyer may have certain interests in a building, or want to live in a building, but they can't because of a certain dog they have. So it's important for them to take a look at that before they maybe waive everything.
Right. And especially when I have clients, it's like, well, I have 2 dogs. It's like, well, I had a client saying they had 3 dogs. I'm like, 3 dogs generally are not allowed in condos, having that many. 2 often is okay in some buildings. So again, that's one of those things. It's like, yeah, we have to really look at that.
Yeah, it's also important to think about the culture of the building, right? So I lived in a condo once where it was quite open to large dogs, but that's not every building in Toronto.
No. And I lived in one where we had a Great Dane that sat almost 7 feet tall. It was this giant dog. Scared the crap out of people who were afraid of dogs.
Yeah.
And it's like, so if you're afraid of dogs and you're moving in a building that has dogs, you might want to reconsider that.
Yeah.
So that's one of those things that I kind of pay attention to now, because I had a client that was very sensitive to dogs.
Yeah.
Or noise, or this type of thing, or whatever. So I think on the status certificate, looking at not only the accounting and the rules and regulations, a lot of times there's the declarations and things are very similar building to building. So you probably don't spend a lot of time on that, I'm guessing?
Well, we look at the bylaws. We want to make sure we take a look at what the definition of a standard unit is, and we do have clients that will want to make renovations in a unit that they're going to be buying, and so we talk to them about the process of getting approval beforehand and what that looks like. And we also talk about increased need for insurance if you're getting a mortgage, because oftentimes the building insurance is not adequate. So there are things that we generally take a look at, but it's a lot of documents, and so it can be overwhelming for clients. So we have to make sure that we do a thorough review and make sure that they have it in their back pocket if they ever want to take a look at something about the building later on.
And I always encourage, especially my first time buyers, like take a half an hour, read through the entire form. I know it's boring. There's some of it doesn't apply to you, as the buyer, but it applies to the corporation as a whole, like how you elect officers and how people are removed and how they choose this and how they choose that. Those are all in the rule, those declarations of when the building was first, occupied.
Yeah, I'll give you a really good example of an issue that happened not too long ago. I had some clients who bought a penthouse unit and with a skylight, and there were some issues with the cracking of the skylight. So we had to make sure that the skylight was part of the unit that the building would actually cover, so it wasn't going to be paid for out of pocket, right? So there are some things that are unit specific.
Yep.
That we need to make sure that are covered under the condo documents. And because depending on what unit you're buying, that might impact things as well. Yeah.
Well, and I had the incident where I was in a building that had Kitech plumbing. We actually discovered it because one of our pipes broke.
Mm-hmm.
And reading through the declaration, it says what's the responsibility of the owner, what's the responsibility of the condo.
Yeah.
And in the condo I was in, the condo was responsible for all of the kitchen cabinetry. So all the kitchen cabinetry got damaged, and they didn't want to pay to replace it. It's like, I said, we can go to litigation over this, but you've got the declarations that say this is a standard unit, and
Yeah.
you're responsible for the kitchen and the vanity and
Yeah.
blah, 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 blah. The windows. I think the windows are a big one for a lot of folks. Sometimes the corporations are absolutely don't do anything with the windows and the doors, and sometimes they're 100% responsible.
Or a balcony.
Yeah.
Yeah.
So, and people don't understand, and they're like, well, I own my balcony or I own my outside terrace. It's like, well, it's common area for private use, or for your own use. So it's owned by the corporation and managed by the corporation. So you can't like build on your patio. You can't build on your terrace.
And if it's a common element.
Yeah.
Yeah.
And it's considered a common element. So I think a lot of, especially people who buy on first floors, they struggle with, oh, this is my terrace. It's like, well, yes and no. It's your private use terrace, but it's owned by the corporation. So if something happens, the corporation takes care of it.
Yeah.
You don't. So that you have a shared responsibility there.
Yeah. One thing I do find that a lot of buyers are unaware of is that if they're buying a unit with a parking spot and a locker, that the parking spot and locker are often individually deeded. And so when we close, we're actually transferring over more than one thing. There's going to be the unit that you're buying, potentially a parking spot or more than one parking spot, and a locker. So all three things are being transferred over together. Sometimes unit owners will want to sell a locker or a parking spot, and so there are rules and restrictions about who you can transfer things to. Generally, you have to be an owner in the building, and if you are trying to transfer something over to another person in the building, if it's subject to a mortgage, there are issues too, and you'd have to get the lender to release their interest. So lots to think about when you're buying a condo, but definitely a good way to get into the market before you want to go to the next level.
Absolutely. And that's how I talk to my first time buyers, like, this is the time to jump in. Jump in now. Prices are low, mortgage rates are low, you can get in with 5%, there's lots of other incentives around, land transfer tax rebates and things like that. Great time to jump in.
Yeah, it's a bit of a buyer's market for condos right now,
Yeah.
that's for sure.
And it will be for a couple of years.
It will be, and especially for first-time home buyers, there's less things to think about living in a condo than if you're buying a home, just in terms of how it impacts your budget for capital expenses, capital repairs, and property taxes too, which will be more expensive.
Right.
Yeah.
Well, and especially because people think, well, it's too expensive to live in Toronto. I want to live in Mississauga. I want to live in the Durham region. It's like, great, but your taxes are reflective of that, and your taxes outside the GTA or the central Toronto are generally twice what they are in the city. So your property taxes are more. So your ability to buy more doesn't necessarily translate there.
Yeah, and we're kind of in a different phase of the pandemic where more people are going into work again, and so transportation costs may increase as well. So people need to often think about their global budget in terms of what they can afford, because if your housing costs have gone down but then your transportation costs have gone up, you may not be saving yourself any money.
Right. And that's why I get people to start with the financial plan. It's like, let someone help you look at what your plan is.
Yeah.
And if you're going to a condo, there's a different type of plan than if you're going into a house.
Yep.
And if you don't plan for those emergency expenses in the house, you can get screwed really quickly.
Yep. Yeah.
So it's like, it's big challenges. So we've made a deal, we've signed the paperwork, the conditions are in the process. What's the next thing that a buyer should know as far as where you come in and what you do?
Yeah, so a good question. It's usually around this stage that we engage with people or clients or prospective clients when they're in a conditional period, where we talk to clients about what that really means and the status of a transaction. And, you know, again, we may be approached by a buyer or a seller. And so the respective interests are going to be different. And so specifically, with respect to buyers, what we want them to understand is that the status of what a conditional deal means and how it is not, or what it means when they have a firm deal. And so once the conditions have all been waived and we're in firm territory, that's when we have to really make sure that we are getting all the information required by the buyer in order to close the transaction. And so I generally tell clients it's kind of a series of holding patterns. The first holding pattern could be, if you reach out to us before signing anything, is finding something that you like. The second period is once you've signed an agreement and it's been accepted, once all the conditions have been waived. The next phase is going to be working with us to get information from the lenders to make sure that we understand how much you're getting funded, and then it allows us to prepare the paperwork, work with the seller's lawyer to deal with any issues on title that we need to get cleaned up, prepare all the paperwork and all the financials to determine how much will get funded and to work with the lender to get that money. And then how much money we're going to need from the buyer as well, factoring in any rebates that may be applicable, the land transfer tax costs, legal fees, and disbursements.
So I'm just going to go back just a little bit. So a lot of folks don't understand what conditions mean. So for me, our general, or I see our general conditions being an inspection. Most first-time home buyers want an inspection, condo or house. And I encourage them to do that because it helps them understand where everything is. It's like, where do you shut the water off? Where do you turn the heat on? What happens with the air filters? How do you clean the dryer vents? Because in condos they're a little different than in houses. So an inspection is, you know, a common thing. We also do conditions on financing. Because we want to have, it's like yes, you have a pre-approval, but that doesn't mean you're going to get that mortgage. Because people get confused, like, well, I have a pre-approval for, I'm pre-approved for this amount. Like, that's great, but that doesn't mean your mortgage provider is going to provide that mortgage to you. So you have to go through that process. And if you're scared about it, put that condition in. So status, condition, financing. There's always one more.
Status certificate is another big one in
status,
the
yes,
condo
of course.
world, right?
Yes,
yeah, those
absolutely.
are the three big ones.
Yeah. And we want to have the time to review the status. It's like, yes, it may take you 10 days to get it, but you're only going to get 3 days to review it. So have that during that conditional period, that 10 days waiting for the status, talk to a lawyer.
Yeah.
Do that negotiation, do that piece now. And what I've learned, and I just had this feedback from one of my clients, is like, I give it to them a little bit at a time, rather than tell them everything they have to do at once. Because it's overwhelming for most folks, especially first-time buyers. Like, let's focus on getting the conditions done. And once the conditions are done, yes, we can look at the place again. But in that conditional place, find a lawyer. Get those pieces done. Then all these other places, because if you're doing the conditional, you already have a relationship with a mortgage broker in my mind. It's like, if you don't, we're too far ahead. Don't put the cart in front of the horse. This is the old saying that I grew up with.
Yeah, and again, it might also be property specific. Like, those are the general ones we find for most transactions, but there could be properties where there's questions as to the status of parking.
Or surveys.
Now, surveys are generally not something that are part of most transactions anymore, just because a lot of them are out of date, and they may be covered by title insurance provisions. But there could be properties that have specific issues that you want to make it conditional on. And so it'll depend on the property that you're buying.
Right.
Yeah.
Well, and nowadays, especially when people are buying a detached or semi-detached home, they're looking at auxiliary dwelling units. It's like, can I put one in?
Yeah.
So for me, when I'm putting a property on, I call my buddy who gives me just a general overview, can you or can't you? Because it becomes it's basically an asset that the buyer can exercise if they choose to, versus like, oh, we can't do it, because there's some places you can't. Like you can't on certain ravines, you can't on certain corners, just you can if the fire department can't get back to it. That's a new one I've learned.
Yeah, access issues.
Yeah.
Yeah. A lot now. We see a lot of that more in properties that are outside of the GTA.
Okay.
In rural properties where there may be some access issues, but those are issues that definitely do come up every once in a while, and we have to know how to handle them properly. Yeah.
So the conditions are done, you're talking with either the mortgage broker or the bank or both. I'm not sure if you work directly with the brokers or you talk just with the institution they've assigned you to. And then what's the sort of, as we get towards closing, what are the things that are happening?
So we often work with a broker sometimes. We will communicate with them directly, but a lot of times we're working with the funding department of a bank. So let's just say Scotiabank, just because that's my mortgage. We will often work with the back office of the funding team.
Okay.
After everything is broker complete, and then so we will communicate with them through a certain avenue. Or in the case of a private lender, we will be working with counsel for a private lender. So in Ontario, if you are getting a mortgage with an institutional lending client like a bank, we also represent the bank's interest. So if there's a conflict between the buyer and the bank, let's say over an interest rate provision, we can't take sides. It has to be mediated beforehand. If you have a mortgage with, let's say, a private lender, we cannot represent them. They have to be represented by a private lawyer. And so we would communicate with them. And so we will communicate with them about the funding. Yeah. So
the other thing that I learned in all my work is that the buyer and the seller can't be represented by the same counsel.
No, the Law Society has some rules that, when it might be acceptable, but it's very rare. I think if you're in like a small town or something like that.
Oh, okay.
But generally, you cannot represent people who are on opposite sides.
That conflict of interest stuff.
Yeah.
So can you talk about the statement of adjustments? Because that's the piece that comes just before the buyer brings you the check.
Yes, and it sort of becomes the basis for all of our accounting work. And so a statement of adjustments is a document that's prepared by the seller's lawyer that adjusts for certain things like the deposit that has been paid by the buyer, as well as potentially two other issues. Definitely property taxes, but also in the case of a condominium, condo fees. If you are selling, let's say, January 15th, a buyer is responsible for the fees after you buy. The seller is responsible for certain fees up until closing. So we have to determine what is their responsibility, and we adjust those numbers either in favor of a buyer or a seller. And then when you take the purchase amount, deduct the deposit, factor in those two adjustments depending on which type of property you're getting, and potentially some other issues. There could be some
taxes.
If
people are paying their taxes yet or paying them quarterly or whatever, that's a big thing.
Yeah, then that tells us exactly how much is owed to the seller's lawyer on closing. That doesn't mean that's how much we need to close the deal. It simply tells us how much we owe them. Then we have to deal with land transfer taxes and fees.
And deposits.
Yeah.
Yep.
And then from there, once we know the total amount that's required, we factor in, well, how much is your lender telling us they're going to give us? The difference, we tell the client as soon as we possibly can what we need them to wire to our account. In our industry, wiring has become the norm because of bank holds. It used to be the case that lawyers didn't really have to worry as much, especially if you did a lot of transactions in your trust account, but we are all facing holds now, so we only accept wires to our account. And I will usually canvass what institution you are sending money from, because I generally will know what the processing times are for each bank. And we need the money in our account at least one day before closing to make sure that we have everything to go the morning of. And so often is the case if we're on the buying side, we have to wait for the seller's lawyer to prepare the statement of adjustments. And so to get around that, I always order tax certificates on every transaction, because it allows my staff and I, to make sure that we know what the tax situation is on the property that we're buying. We're not solely relying on the seller's information.
So they're not in arrears or anything
Yep.
like that.
And if we think that we're getting a little bit too close to the closing day and we haven't heard, that we will send our draft statement of adjustments for approval as to form and content, because we have no control over how busy another firm is.
Right.
So, as a lawyer too, I can only be in control of what I can be in control of.
And then you rely on the realtors to make sure everything is in order, of course. Because I had a client coming to closing from out of town, and on the phone in their car, they're like, "We don't have insurance." And by the time they got to the signing, they had insurance.
Yes.
It was like there's certain things that are actually required for it to close.
Yeah, that's right. And, well, the insurance thing's an important thing because we as lawyers cannot release funds if we're buying without proof of insurance. And again, because we represent the lender, we have to make sure that we comply with all of the solicitor requirements. So when we get mortgage instructions, there will be a provision saying that property insurance is required. And they will detail in the instructions how a lender wants to be noted on the insurance policy.
Okay.
And so we have to provide that information to the client to tell them to speak to their insurance provider to provide usually an insurance binder before closing. And we need to review that to make sure it's approved, because sometimes we will have to make changes to addresses and so forth. A good example is a lot of lenders will have a retail service department that they work from, and they want that noted as the address, but maybe a client is working with a particular branch, and they put the branch address on an insurance policy. So they get the policy, but it will come back later and say it needs to get fixed. So I'd rather have everything ready to go on day one.
Yeah, me too.
Yeah. Yeah.
So
Yeah.
let's make this, that's what I tell people is like in every transaction there's a bump. And we don't know if it's going to be at the beginning or the middle or the end.
Yeah,
And so to really be on task with that.
Yeah, and the thing about insurance is the reason why lenders require it is that if there was a fire, they want to make sure that they're the first loss payee.
Yeah.
Yeah.
Yeah, because things like that happen. Not on every closing, but every once in a while something will happen.
And it's becoming more, it's required for condos as well. You can't just rely on the building's insurance. You need to get unit-specific insurance.
Yes.
Yeah.
Yeah, for sure. So once the statement of adjustments is done, people bring their money in. My conversation with my clients
They
is,
wire us the money.
Yeah, they wire. So yes, we'll have that conversation too. That's a funny one. They've figured out what the funds are. They get it to you. I advise my clients, it's like call your lawyer 7 to 10 days before to set your signing appointment up, because you have to sign a lot of documents. But at that point, it's like you will advise them, okay, now here's the money that has to go in, so that then there's no surprises in the next 2 or 3 days as we come to closing.
Absolutely, and we also need to, we have certain requirements for the Law Society to get a sense of where the client funds are coming from.
Mm-hmm.
We need to document that, and we need to, but again, there's sometimes we can only provide, well actually in all cases, we can only provide that information once we know how much someone's being funded. Oftentimes lenders will send us instructions well in advance. Sometimes they take their sweet time. And we can only do the calculations once we have that information.
Right, and
So.
the other piece because I work with a number of buyers that are here and they have money overseas. And I'm like, it has to be in your account 90 days before you close. And it will have been screened to make sure that it fits within the FinTrack capacities, because we track FinTrack, you track FinTrack.
Yeah.
I mean, we're the financial, we're the financial bankers for CRA and the government.
And so the other thing, for people who don't know, FinTrack is really the financial crimes unit. We have new requirements to report identity to our title insurance providers with regard to FinTrack rules. So there's more compliance issues on our end as well. Fraud is a real thing. And so we always have to make sure that we know where the money's coming from and that we document everything appropriately.
Yeah, my favorite story is the client coming into closing with a briefcase full of bills.
Yeah.
It's like, yeah, you can't do that anymore.
No. Well, and you know something, what we are seeing now more frequently is where the lender is the bank of mom and dad.
Mm.
And so that's on top of maybe a mortgage. And Potentially, it's a file where there's also a spouse, but not a married spouse, a common law spouse. So there's a whole bunch of things that we need to also factor in as to when additional provisions and work needs to be prepared about. Is money being loaned from other sources? How is that going to get managed? Is it going to be done through a mortgage? Is it going to be done through a promissory note? You know, there's a lot of other things we got to think about.
Yeah, and I've had that with, I deal a lot with couples who are separating or divorcing. And it's like one's funding the other, and it's like, well, where's that money coming from? And it's a corporation, and it's like, it gets very, very convoluted. And it's like, go and get that stuff cleaned up. That's what the lawyers will help you do, because it can be very complicated when, you know, you've got a divorcing couple and there's kids and there's not a parenting agreement or there's not a separation agreement in place, and we're funding a mortgage.
So, you know, two things. As it comes to family law. I'm not a family law lawyer, but I have very good contacts. I used to do a little bit of family law, but it wasn't for me.
Not for a lot of people.
But real estate lawyers need to be very, very careful with these types of transactions, specifically as mortgages are required, because we have to make certain statements with land registry when we register documents as to spousal status. Because spouses have to consent to mortgages if they're not on title, or unless they're part of the transaction. But, you know, where we have clients who are buying together, and I often find where I say clients are test driving their relationship through real estate. Maybe they're common law, they're not legally married, so there's different sets of rights that attach to whether or not it's a matrimonial home or not. Maybe one is throwing in more of a down payment than the other. This is where potentially a good domestic contract is really important to be done in tandem with the actual transaction. Those types of files, I want to talk to the clients immediately, because it takes time to prepare these documents. And so I will usually refer them out to different family lawyers to prepare a domestic contract, which could become a marriage contract if they get married, which would also form the basis of a separation agreement. But also from the selling perspective, when I have clients who are selling, if you're going through a separation and you don't have a separation agreement in place, or you don't have minutes of settlement from a court or anything, we can't release funds to you, because we have no idea who's going to be owing who. So, and I've had files where I've had money sitting in my trust account for over a year. So where there's a family law element, we have to be very, very careful.
Yes, I had one of those, and it was very complicated.
And I will say, we've also had more files recently where, again, getting back to this ability to buy in unique ways, clients who are buying, let's say, one person with a married couple.
Okay.
Which attracts different types of concerns, where it's a matrimonial home for two of the people and not for one. And so having really complex co-ownership agreements put in place.
Yeah, and specifics, like what happens if? Like, one wants to get bought out, what does that look like? One dies, what does that look like?
Well, so I generally will tell people in these types of circumstances, one of three things is going to happen. You're either going to sell the property, one person's going to want to get bought out, or you're going to die. And so all of those three things need to be considered as an exit strategy to a piece of real estate, because, you know, for first-time homebuyers, it's hard for them to even think about, and this isn't saying everybody needs an ownership agreement, but when you're going to buy something for the first time, at some point you will let it go. And we don't know how that's going to happen, which also speaks to why it's important for everyone to have a will.
Which is important.
Yeah.
We'll get into that. I have a whole stuff on that. But so let's finish the money's in. So when do you prefer that clients sign documents?
I usually want it to be within the week before closing.
Okay.
Depending on the status of the file, if we're file complete, I have a little bit of flexibility. And so on the sale side, even sometimes we'll have like the day before.
Okay.
I generally like to do it a little bit beforehand. On the selling side, it really is dependent on whether or not I have a mortgage discharge, a payout statement for discharge purposes, because we need to know how much the clients will be getting, if any. In some cases, people are very leveraged, but we have to know how much we're going to be paying out to a mortgage. On the buying side, I like to have it as soon, meaning as soon as we know what the financial circumstances are so that we need for in our file, in our account, and to give clients enough time to get to the bank to wire the funds over, because sometimes it can take a couple hours or a day or two for the wire to show up. So generally, I want it a couple days before the actual closing date.
Okay. Do you do everything electronically now?
Yeah, good question. So there's a lot of things that happened during COVID that have actually allowed us to practice differently. Real estate specifically is mostly done virtually. The closing process is done virtually. Electronic document registration with land registry is done online. We can meet with clients to sign documents remotely because we can watch them sign documents online, and clients can wire us funds.
So what about identification?
Yeah, so we have a process where we have to independently verify someone's ID. So we have an online program that we send to clients to upload a valid photo ID and take a photo, and it runs it through a system, like a biometric system, to make sure that it's compliant. We have to do that for the Law Society and for lenders. But that's in the app. If we're meeting in person, and there are clients that do want to meet in person, where I can individually look at your ID, I can fill out certain forms to make sure that we're compliant for that. I have a range of clients from young to who are a little bit older, and for some of my older clients, they're not as comfortable with
Right.
online platforms.
I agree.
I will bend over backwards to try to make it easy for them if we can, or I will go to them. As long as they're in the GTA.
Right.
Our fees might change a little bit if we have to come see you, or if you're coming into the office and you want to sign, that's fine too. It really depends on what people's preference is. I usually say you don't have to come and meet me in person if you don't want to, but at the end of the day, we do need to get everything signed.
Right. So the registration process is what happens after the signing.
Yes, so the closing process is really where the buyer and seller's lawyer have exchanged documents, and we are satisfied as to the documents provided. And then closing takes place once the buyer has sent the money, it's in the seller's lawyer's account, we've exchanged documents, and then the seller's lawyer releases the deed really to us to register electronically.
So Leslie, tell me about this new thing, old thing, confusing thing about vacant home tax.
Yeah, so it's a fairly new regime that is in a couple different municipalities now, Toronto being one of them. As an attempt to prevent underused housing, owners are required to file a declaration online. A property was owner occupied during a certain year. There are certain exemptions that could apply. For example, if someone passed away and they weren't, so their estate trustee would have to file it for them, but there's an exemption. But every year around, I think the portal opens in Toronto in early November and it closes in April the next year, you have to file the vacant home tax declaration. The key thing with this is that it doesn't follow the owner, it stays with the property. So if a seller failed to do it, there's a fee that would show up on the tax bill that would be the buyer would assume. So we always have to now make sure that the filings are complete. So what I generally require from my sellers is that they send me a copy of their tax bill so that I could log into, or they can show us proof if they log in actually, to the City of Toronto portal to show that the filings have been completed. And then they will also sign a declaration as part of the closing documents that they have filed the most recent one. And so it's a new thing that we have to do as part of our closing procedures. For first-time home buyers, it's sort of a harder thing to kind of to understand, like, well, what is this thing, right? So I generally will tell people as part of your paying your property taxes, at the end of the year, a portal will open up on the City of Toronto website. You have to go in and just say that you were occupying the property. But if they have any problems with it, they can contact me and we can help them do it. I think Ottawa does it, and a couple other municipalities are doing it as well. Yeah.
Yeah, it's that affordability, empty housing crisis stuff we have going on.
Yeah.
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 Yeah. Big challenge. So that other aspect of your business, which is estate law, how does someone engage you or get involved in that? Because I know people People are often asked to be an executor for someone. I actually wrote a book on it because I had a client who was asked by two people to be executors, and she had no idea what was going on. And she's still entangled in this several years later, unfortunately. So I think people don't really know. It's like, well, I've got this book. It'll help you. It was the longest book I wrote. It was like 150, 160 pages.
The longest you wrote?
There's so many details. Well, write simple home buyer, home seller type books. Just kind of an educational piece. And no, I have. No, it's like, no, I'm not a big book writer. It's little things that work. So, how are you involved in someone's estate? Or how do you get involved in someone's estate? Someone calls you and say, my wife died or my person died, they don't have a will.
Well, just tying it to the real estate piece, I canvass with all files whether or not someone has a will, whether you're selling or you're buying, specifically if you're buying, because if you own real estate in a certain jurisdiction like Ontario, you should have a will because property is governed by provincial legislation. And the thing about when you're buying, just connecting it to the real estate side too, when two or more people buy a property, there's one of two ways you're going to do it. Married spouses, for example, generally own as joint tenants, meaning that there's a right of survivorship. If one partner passes away, the entire property passes on to the surviving joint owner. And so as a real estate lawyer, for us, what we do is we prepare what's called a survivorship application to remove someone. The other way that you can own property is as a tenant in common, where two or more parties own a fractional percentage of a property, 50-50, 70-30, whatever it is, 99-1. In fact, I see a lot of people who buy property who can't qualify for financing, so mom and dad have to come on title for private for lending purposes, so they come on for 1%. But if you own as a tenant in common, when you pass away, your part of the property doesn't automatically pass on to someone else, it goes through your estate. And the question is, do you have a will or do you not have a will? Because your will is going to provide the framework of what's going to happen with your assets. It's also going to provide who you want to be the representative to deal with your assets. And so we get lots of people who reach out to us to prepare their wills and their powers of attorney that have not real estate clients, but then we have clients who are real estate clients who are also estate clients. But we also get contacted by people who, let's say someone passed away and they don't know what to do, and so we get hired by estate trustees. Sometimes there's a will that's been prepared by another office, or in some cases there is no will at all. Then that's where it gets interesting because everything is governed by legislation.
Right.
Yeah. So our job in that case is to, if we get hired by the estate trustee, to guide them through the process. And depending on the assets in question, there will be different requirements.
So you use the word estate trustee versus executor.
They're interchangeable terms.
Okay.
Yeah.
Because things can be confusing when it comes to law.
Yeah.
So it's like,
Yeah, an executor is someone who oversees the overall administration, but there might be a trustee in a will who oversees a specific trust. But I use that term sort of interchangeably.
Okay. Because if I sense the confusion, I know that someone listening will be like, well, who's that? What is that? So then what is your role then as a trustee or an executive? Your specific role as a lawyer in this process?
So let's say someone has passed away and there is a will. So what we will do is we will review the will with the client to make sure that it's a valid will. Often is the case nowadays. I'm getting a lot more wills that were prepared around 1990 or so by other lawyers that don't have certain affidavits that are required by the court, so we have to chase down witnesses to get things signed. But then we have to, our job is to guide the executor with their role and responsibilities of what being an estate trustee means, and to the extent that they accept that appointment. And probate is required, which is a process where the court certifies the will and provides a certificate of appointment of a estate trustee. There are certain requirements that are part of an application. We need to know what all the assets are, how they're owned, and explain to clients what goes through the will and what assets may not go through a will. For example, if someone passes away and they own a property jointly with someone, or they have a bank account with someone jointly, it may not go through the will because it's a joint asset. If you have life insurance or an RSP or a tax-free savings account with a named beneficiary on it, goes outside of the will. And so it's really also important for all people to make sure that they have their wills prepared, because we can actually do a lot of things in a will to make sure that your intended goal of where you want certain assets to go will do just that. Because if you don't have a will, and certain, you make certain provisions before you pass away, there can be some unintended consequences,
Right.
including tax consequences.
And CRA wants its money first.
Yeah.
I've learned that several times.
Yeah, well, and that's the other thing too. One of the key things we advise estate trustees are the importance of getting clearance certificates to make sure that, before you make distributions to people, that the money, the government is satisfied they've received everything.
Well, and the CRA, my partner and I have helped settle several estates, unfortunately, but we have. And one of the states had, was several $1 million with all of these charities to donate to, international charities, which made a big difference because they needed. CRA wanted, notes from the charity. They had to be certified by whoever was the head of the charity, the names of the charities overseas, before they would allow any of that. And it took many months, even though the charities knew they were getting money. It was like to even get anything distributed, because CRA was like, well, can we tax that? Can we tax that? Can we tax that? That was the implication that we were getting.
Well, and the longer an estate is open and not settled, there are ongoing tax reporting requirements as well. So that's also why a good accountant is important as well.
Right.
So,
yeah, and get everything put into an account that's not interest bearing, so they're not having to declare the interest the next year or the next year or the next year, however long. So in general, in Toronto, because I know we have to be specific about this, how long is probate generally now?
Again, it depends. So I explain this process to clients also as a series of holding patterns. The first holding pattern is after someone passes away until we're actually contacted. Sometimes it's a day after, sometimes it's a couple months. And then it's going to be a fact-finding and information-gathering process of trying to understand the assets, communicating with banks, institutions, getting all the required appraisal documents if real estate's involved, preparing the application, getting it into court. Generally, we're seeing, I say, let's go by 4 to 5 months. If we're lucky, if it's earlier, that's great. If not, we start following up. But I kind of am starting to use the 4 to 5 month as a guideline.
Okay.
The issue is that during COVID, office hours at the estate's desk in Toronto were modified, and then there were less people working, and so it just things got backed up.
Yeah.
I think that backlog is clearing up a little bit. I've seen faster processing times, but it's still a process.
Yeah, I always kind of go on the premise of 9 months. It's like having a baby.
Well, there's a general rule, executor's year, but
Yeah.
that's not a hard and fast rule.
Right.
It's a guideline.
Right.
Yeah, and then it depends on what happens afterwards. Sometimes you'll have someone who wants to wait to sell a piece of real estate because it's not a good time in the market. We see that quite a bit, and so from the beginning to the end, it can often take like 18 months, maybe a little bit longer. Could be shorter too, depending on what's going on in the estate.
Yeah, I had a client that was dealing with patents and publications and things that were owned by the deceased, and figuring out how to get all of that resolved. And I think the last time I spoke with them, she was near the ending, but it was about 5 years. And I'm like, that feels painful.
Well, it does, but there are cases where there's a lot of things going on that hit a bunch of different legal trees, right, or branches, and so again, when someone is looking at whether or not they want to accept the appointment, because just because you've been appointed into a will doesn't mean you have to accept it.
Correct.
But you can't start acting like an estate trustee. The moment you start doing that, the train's left the station. There's a process later on for for resigning. But you generally want to have a sense of what's going on to determine if you can handle it.
Yeah.
And our job is to guide you through the process, to let you know what your rights and responsibilities are as an estate trustee. And we don't represent the beneficiaries. We can provide them information but not advice. But we will often be retained by beneficiaries who have an entitlement to an estate, where we have to communicate directly with an estate trustee or their counsel to get information.
Right, and the beneficiaries can be like, where's my money, where's my money, where's my money? And the executor has to go, you have to all sit back and take a chill pill and wait so the process works.
And again, people don't know what they don't know.
Right.
And so if someone has an entitlement, they don't necessarily know what that entitlement is. If you've been named as a beneficiary, a will often doesn't tell you what the assets are. There's a process for finding out what that is and determining what the net amount is to each beneficiary, but it can take time.
Yeah. And there are a lot of twists and turns and roadblocks that sometimes people put in their wills, like multiple executors.
Yeah, there can be, that is one, and the question is what happens when there is dissension amongst executors, because they all have to do it together. And so that's one possible issue. Another thing is making sure that funds are released from institutions and dealt with. There's a whole bunch of things that can cause problems. But again, where there is, let's say using the example you gave, executors have a fiduciary duty to administer the estate and towards the beneficiaries. So, people have to be very, very careful about what they're agreeing to and not agreeing to.
Especially when executors are actually beneficiaries.
Yeah.
So it can get more and more and more complicated.
Well, and in the case of where an executor is the only beneficiary, or is one of maybe a couple, in the case, let's say there's two kids and one of the kids is an executor, sometimes, more frequently, we find that executors self-administer the estate. They may not engage our services or another lawyer. They may choose to do it, but if it's a relatively simple matter. But there are still certain things that they need to be careful of. Yeah.
Yeah, we did that with my father, who had very little, and my brother managed that, and it was simple to a point. There's still some complications in it, but it's like that's easy. But when you're talking millions of dollars, it's often a whole different ballgame.
Yeah.
Yeah. So, any other thoughts on that maybe we haven't covered around the estate and executors that sort of would be important? I know that the executor process is very complicated, but in general.
I would say that if anybody has any questions, to feel free to reach out to us if they have any specific questions. But the important thing is everybody should have a will. Even if I'll often hear, well, I don't have much. It's not even so much about that. It's about making sure that you have control over who is going to act on your behalf if something were to happen. Parents with kids, absolutely, you're on my hit list of people to have something done. The young and wealthy. I'm seeing more people who are under the age of 40 who have significant assets, who I often will try to get them to understand the importance of having something done. And also, the other thing is the understanding the nature of the assets that you have and how they will be dealt with. People often don't understand that. And clients of mine who have privately owned corporations, there's a lot of things we can do to try to reduce the impact of estate administration tax. I could have a whole conversation about that in the future, through having multiple wills. I actually was having this conversation yesterday with a client who lives in British Columbia, but they own real estate in Ontario. The importance of strongly considering having an Ontario will for investment real estate, because you can have multiple wills to deal with multiple assets in different jurisdictions, so that if something happened to you, you can walk and chew gum at the same time, deal with assets in multiple jurisdictions at the same time.
The other thing that came up in sort of my research on my book was having an executor for your social media presence, and figuring out how to deal with it. Because say you're an influencer and you're getting X dollars from whatever you're doing, or you've got Facebook stuff or in my case, I've got ebooks. It's like having someone that's all they deal with is either cleaning up or scraping or closing out all that social media stuff. And that seems to be a fairly new piece that's sort of coming to the surface.
There's a lot of chatter in the past couple of years in the world of wills in the States with respect to digital assets and how to deal with those. Whether it started off with Facebook accounts, cryptocurrency, but social media accounts for sure. I have some clients who they have very strong social media presence with a lot of followers, and they're influencers.
So Leslie, something that's come up really recently is social media and social media presences. And it was in my research for my executive book, there was a suggestion of having an executor just for your social media. What do you think about that process now?
Yeah, so I have there's a lot of chatter in the most recent years of in the world of wills and estates specifically about how to deal with new and emerging assets, and digital currency is definitely one of them. And so you don't necessarily have to be Kim Kardashian with whatever 100 million followers to have value to a social media presence, but they're worth something for many people. I've got clients who they have a very strong social media presence. They've got businesses that are tied to them, and so there are certain requirements based on what type of digital currency it is with respect to how to manage it. Not just as Facebook, Instagram, TikTok. I'm not on TikTok, but it's a...
I guess I saw put on TikTok, but I'm not a TikToker. I don't sing and dance.
Yeah, but it could even be something like access to your iPhone, right? Cryptocurrency was a big thing. It still is a big thing. So what we do is in a will, but also in your powers of attorney, we make specific provisions authorizing your power of attorney if acting as your power of attorney for property, or to an executor if acting under your will, to be authorized to specifically deal with your digital content. And so that is an issue that is becoming more and more prevalent nowadays, because we are in a digital world, and most of us have some sort of currency, even if it's not what we think in terms of social media, but it could even be online banking, or just passwords to things, right? Yeah.
So it's the Law Society making sort of changes or looking at that, or
I think it's really like we certainly include clauses in our documents specifically authorizing decision makers to be able to deal with these types of assets, so that if you go to a company that oversees an account for someone, that they know that this is the right person to deal with. But part of the question could also be, how do you value these things, right? Do you need a special trustee in the case of someone passes away? Or is it something that a prudent executor would be able to manage? And I think the question is, what level of digital currency are we dealing with? And do we need to make special provisions about it? Like any asset, it needs to be canvassed with a client to determine what the scope and breadth of it is, and whether or not it needs special planning.
Yeah, which makes it much more complicated, and especially for an executor who's perhaps it's the first time they've been asked to do this. They literally, their education curve is huge, and there may be a point where they're like, I don't have time for that, or I can't do that.
Sometimes, well, actually, I should say more often than not, I'm hearing these days, I can't get into someone's computer, or I can't get into their phone, and so just on a very basic level too, people should consider having passwords written down, because digital currency could be access to an electronic device. It could be a whole social media platform. And so I have written down all my passwords. But I don't have a huge online content. I always think of the Kardashians as an example of someone who probably would have to get valued. But real estate agents often will have quite a few social media followers, right. Or influencers might. So it's a brand like any business.
Yeah, which makes it's like it fits in some categories and not in other categories.
Yeah.
Especially as we move more towards digital and chatbots and all this other stuff. It's like, are we going to get into a tight space where people are like, I don't know what to do with it?
Yeah.
Which is interesting. I mean, it's just, for me, it's having that curiosity to think ahead. It's like, oh, what happens if?
Yeah.
My partner's like, oh, it's all online. It's like, well, yeah, but if I don't have your phone and access to your phone, which you need to do double identification, then I'm screwed, right?
Well, and one thing that estate trustees often have to think about nowadays is, closing off Facebook accounts or Instagram accounts or those types of things. So those are practical things that people need to do as part of winding down an estate.
Yeah,
And if you can't access that content, what do you do?
Yeah, because every once in a while I get it's so-and-so's birthday. It's like, they died 5 years ago.
Yeah.
And it's like, so someone didn't think about that or didn't plan that, or it's like, yeah, that one that makes it uncomfortable at times, or it's like, oh my God, this is going to be here forever and ever and ever and ever and ever.
Yeah, my mom passed away about a year and a half ago, and I chose to keep her Facebook page going as a reminder, but that's not something everybody would want to do for someone if they're acting for someone. So,
Yeah.
But it is it's an asset. It's just a different type of asset.
Yeah. It's like go to
It's
law school.
not real property.
Yeah, it's like go to school, go to law school. This is a very good law school curiosity thing.
Yeah, we didn't talk about digital currency when I was in Wills and Estates back in law school, and it was certainly not a question on the bar exams.
Yeah.
So that's another reason why we have to do ongoing training.
Start a seminar.
Yeah, there you go. Yeah.
It's a great topic for seminar. I'm sure you could have thousands of people there because everyone's has questions about what's going on, and especially when you're talking about crypto and there's a dozen different, 2 dozen, 3 dozen types of crypto or whatever things out there now, which just drives me crazy.
Yeah.
It is what it is.
Yeah.
So tell people how they can get a hold of you.
Yeah, absolutely. So my website is www.ldrlaw.ca. My company is LDR Law Professional Corporation. Our office phone number is 416-921-3511. And my email address, which is the best way to communicate with us, is Leslie, Leslie, at ldrlaw.ca.
Perfect. Yeah, because you're one of I tell people it's like when I came, because I was a dual citizen at one point, gave up my U.S. citizenship during the first Trump administration, during COVID of all times, and it's like the first thing I did was like get your lawyers and get your accountants. It's like if I'm starting a business or doing a business in the country, it's like those are the first things I want. Someone to help me manage my money and someone to keep me from getting in trouble.
Yeah, we've actually had a few calls in the past couple months about U.S. residents and citizens looking to move up here, and so I have a good immigration lawyer that I send things over to.
And I have a couple who are doing exactly that, and they've already spoken to 4 lawyers, and they're trying to figure out, because they're licensed in a profession that's licensed here and accepted. And they're saying, well, you can come here if you hire people, but you can't come here if you're an individual person, because they do as lots of folks do now, do online therapy and online counseling, online coaching, whatever. And so they're struggling with that. I mean, they're like, well, we're moving money, we're planning, we're looking for places, we're figuring out how to do this. It's like, I'm leaving all that legal stuff to you.
Well, and there are certain rules about who can buy and who can't, and if you fit into an exemption or not. So
yeah, it's like if you're coming up and you're doing it as a business, under your business, it's like that seems to be the allowable one for someone from the States coming in, if they're bringing it as a business.
But then, the lawyers are involved to help with the PR status, because you need to make sure that you have at least your PR status in
Yeah, and that's what I'm like. It's like we look at property.
Yeah.
You keep talking to the people that you talk to, and if you need someone else, you'll refer you to someone else, because it is complicated, and I think a lot of people are expressing that concern about, I don't want to be in this type of environment anymore in the U.S. And it's like, I don't disagree with them. But it's like you can't just come here and buy a property and take a job.
Well, and this is the thing, again, as I've always said, you don't know what you don't know. And there are certain rules about who can actually buy. And so before you sign anything, it's important to understand whether or not you are able to even
do that.
Purchase. Yeah.
That's why I've been calling you. So thank you again. We've completed another very good Swift chat. I think this is a really good. This is something that's going to help a lot of folks in the long run. It's like, yes, the more information you have, the more helpful it is, especially around real estate.
Are you a Swiftie?
I am a Swiftie, but I'm not related.